Good afternoon. I'm Katie Burkhart, and I have David Glazer here.
Howdy.
And we are here on this July 13th, 2011, to talk about overpayments and voluntary disclosures. And if you don't learn anything at all during this webinar, we at least thank you for being here instead of watching the World Cup. And maybe you can take away this history tidbit, which is that the very first World Cup was in 1930 on July 13th. And in that World Cup, the U.S. defeated Belgium 3-0 in that first game.
And please don't tell us the results, because I'm watching the game later tonight with my kids, so I don't want to know what happened.
So because our sports and history knowledge is limited, we're going to stick to our topic here. But before we delve in, I'm going to put in a plug for our next webinar series. So next month, we won't be here in August. We won't be doing a webinar, and that's because we're going to be preparing for our webinar series in September and October, where we are going to be doing Health Law 101. And this two-part series is going to be focused, geared towards in-house lawyers and what they need to know across the very broad and varied spectrum of health law. It's going to be great to get your in-house staffs on these webinars. We're going to have our best people on their best topics during those 2 months. And I believe the first date is September 14th, and that's the second Wednesday in September. So we encourage all of you in-house people to get on, sign up for that webinar. It can also be helpful for people within the client who aren't lawyers, but who also want to know Health Law 101. So.
And then the only other administrative thing, two quick administrative things. One is, just like the government of Minnesota periodically shuts down over the noon hour, the internet periodically shuts down. If our sound quality gets bad, you can use the dial-in number. And the only other administrative point, we have a record number of lawyers signed up today. If you're not in a state where we usually get CLE credit and you want it, just send an email to Katie or me, and we will make sure that we apply for CLE credit in your state.
All right, and as always, we encourage questions, so feel free to type in those questions on the bottom hand of your screen, and we will try to get to them at the end.
In fact, we're counting on lots and lots of questions on this one.
All right, so 2 years ago, David and I spent an entire webinar talking about whether the law requires you to refund and return overpayments. Now, health reform created a lot of questions, but one question it did answer is that now Medicaid and Medicare providers and suppliers have to report and return any overpayments that they receive, and they have to do it within 60 days of when that overpayment is identified. So there are two really big questions looming out there with this new legal requirement, and that's what's an overpayment and what's identification. So just to take a quick look here at the statute, you'll see there's two parts. One, you have to report and return the overpayment. You have to send it to basically the body that paid you, the body that overpaid you. But there's also a second part. In doing that report, you have to give them a reason as to why the overpayment happened. So there's going to be some explanation piece to your reporting, and we're going to really dive into that later on in the webinar, talking about what you say in your letter.
Liz, Katie and I are going to jump back and forth on this. I was actually going to refer to it as a Penn and Teller routine, and then Katie wisely noted that that would keep one of us totally silent. I think everyone was hoping it would be me. I think one of the most significant things here is that you have to disclose a reason now. So the option of just, here's a check, sort of went out the window with this new law.
All right, so one of the first questions that we had when we saw this new law is, what in the world does it mean to have identified an overpayment? And like many laws, the identification term is not defined. So you have to really look at the language. And I think we get some insight as to what it means to identify an overpayment is by looking at what the law is not. So the House bill was actually considering the language that required reporting when you knew of an overpayment. And that seems to suggest that the minute you know there's a problem, you would have to report it. Identification, which is the actual statute now, that seems to require a higher standard. So it's hard to say that you've identified an overpayment until you know exactly how many dollars you were overpaid. And so based on that interpretation, we think there's a strong legal argument that your 60-day clock for refunding the overpayment doesn't start until you've actually quantified the overpayment amount.
And I'd bet my house on that interpretation, but apparently new rules are going to be coming out at some point. That's what there's an American Health Lawyers Association annual meeting, and one of our colleagues, Breyer, was there and heard that I guess CMS is planning to issue rules, so they could screw with our definition, but I'd right now take it to the bank.
For this webinar, we're using that interpretation, but stay tuned. Even broader question, what in the world is an overpayment? How do you know if you've been overpaid? The statute does give a definition, basically saying that an overpayment is when you get money that you're not entitled to. Not super helpful. How do you figure out if you're not entitled to money? Well, I think the best question that I use, the best way to think about it, is to ask whether the law that you're looking at or the rule that you're looking at that you're worried about that you didn't comply with, whether that's an actual condition of payment. Does Medicare, for example, say you have to do that rule, follow that rule in order to get paid? And contrary to popular belief, there are lots of Medicare rules in this context where you don't have to follow them in order to get paid. There might be other consequences if you don't follow the rules, but for example, David's going to talk about this more soon, just because you document the service doesn't necessarily mean that you can't get paid for it. Another common question we get is if, for example, a hospital has not followed the conditions of participation, does that mean that they can't get paid for the services that they provided during that time? And actually, what you'll find out is that conditions of participation are not conditions of payment. And another example, the common question we get is, what if we bill for a service under the wrong practitioner's number? And there's manual language to show that reassignment problems, while they may bring other consequences, does not necessarily mean you have to return money.
So that question of what is an overpayment is an important one. And those of you who have heard our myths talk before, this is a little bit of a repeat of it, but it's an important point to make. The conventional wisdom out there that something is an overpayment is often wrong. In the case of the conditions of participation and the reassignment, there's very clear manual language. The conditions of participation, there's an explicit instruction to contractors not to recoup money merely because of a violation in the conditions of participation. But that doesn't mean it. Both Katie and I have worked on situations where people have tried to recoup money in exactly that situation. The bottom line out there is people will use interesting techniques to change behavior. Uh-oh, Danny, sounds like the monster in the basement has heard you crying again. Let's be real quiet and hope he goes away. All kinds of people have strong incentives to scare money out. And so the first job of anyone when you're trying to figure out a voluntary disclosure is figure out, do you really need to make it? And to be cynical there. Go through the hierarchy. Get a copy of the rule in writing. And most importantly, figure out, is the rule valid? We've worked on lots of situations where there is a theoretically valid rule. We'll talk about a couple of those coming up, where at the end of the day, when you do the analysis, the rule isn't clear and you don't need to refund the money. And so we're going to do a couple of examples of that before we move on to the substance of how do you do a refund once you've found the money. But keep in mind, just because someone sounds smart doesn't mean they know what they're talking about. Relax, Worthington, as the warm, moist air from the jungle enters the cave. The cool, denser air inside forces it to rise, resulting in turbulence that sounds not unlike heavy breathing. It sounds really authoritative until you look at the pile of bones. In any overpayment analysis, when you're figuring out whether to refund money, the core principle is to be fair. And I'll tell you, one of the reasons we're doing this webinar is working with clients who want to refund money because they want to refund money to do the right thing. And when you start helping them, you realize that they're refunding money in a situation where maybe it's a small dollar amount. And they're saying, we want to do the right thing. We're going to blow this off. But everyone realizes if you threw a couple of more zeros at the end of it, you might come out to a different conclusion. You might be more willing to fight or handle it differently. And so one of the core themes that we're going to have running through this is intellectual consistency. If you're refunding money, make sure you would be comfortable if the government applied the same principles to you in an overpayment case. The system should be fair. If you didn't do a service, you shouldn't be keeping the money. If you did do the service, we should, as lawyers, should be able to come up with a reason why you can keep the money. So that's kind of our core operating principle. So I'm going to go through this one fairly quickly because we've done it in another number of webinars, but I think this is like the most common refund situation. So you have an internal documentation review, or maybe you've hired a consulting company to come in and look at your documentation, and you find this. You've got your 5 doctors. Dr. A, she's doing a great job. Dr. B is a perpetual undercoder. Dr. C, who's got 35% of his charts overcoded. Dr. D, who looks like a train wreck with 81% of his charts, quote, overcoded. And then Dr. E, who was the president of this group in a 70-physician group who was using random code allocation as his strategy for picking a code. So he was right a third of the time. So you got a problem like that. What do you do? If you come back and look at this and you say, we're kind of worried about Dr. D. What do you do? So the first question you have to ask is who should do the work? And one of the questions there is, first you call the lawyer. If you're a compliance officer and you're talking here, when do you get your lawyer involved? And that's there's not, reasonable people could totally differ on this. To me, here are the factors that go into it. So first off, who are people going to be honest with? Sometimes that's the lawyer. Sometimes that's the compliance person. You want to make sure whoever's doing it is going to do what we kind of call ask the next question, which is be thorough in their investigation. If you hit the point where you're actually doing interviews, you want to make sure you've got two people doing it, because one of them could wind up being a witness, and also if there's a fact dispute, really two of them could wind up being witnesses, but certainly one of them. You never want to have just one person doing the interview. Obviously, cost's a factor, but then the other one that kind of is the elephant in the room is the attorney-client privilege. And let's talk about that for a moment, because there are so many misconceptions about the attorney-client privilege. I got a call from a consultant that I have a great deal of respect from yesterday, and she wanted me to send a letter to privilege the review that she's already completed because she didn't want it to hang the client out to dry. And I said, I'm happy to do that. The odds are it's not going to work for two reasons. One is the review's already done, and second, and this is what we're going to come up to in a second, the odds are this isn't being done in anticipation of litigation and it won't work. So the privilege breaks into two categories. The attorney-client privilege only applies to advice directly from or to a lawyer. Most of what we're talking about here is going to be work done by non-lawyers, and that's working under something called the attorney-client privilege. It's a different animal. So work that's done by a consultant or done by an employee is done under this work product privilege. And so all that work has to be segregated, and you want to stamp it. But that work product privilege only applies when something is done in anticipation of potential litigation. And so the four-star question is, if we're looking at Dr. D and whether or not he's a compulsive overcoder, is that done in anticipation of litigation? And frankly, we can't answer that entirely. It doesn't hurt to try. There's no harm in attempting to privilege that. But I wouldn't count on it working. So my advice would be to have your lawyer, if you think you have a problem, I do think it's worth getting your lawyer involved, whether that be an internal or external lawyer, and asking them to do the investigation. The cost of that is basically zero. And so there's no harm, and it might work. So I recommend doing it, but you got to know that you can't really take it to the bank. By contrast, the questions you ask of the attorney, that you can pretty much take to the bank as being okay. The exceptions to the privilege are worthy of mention only because it's worth noting if your lawyer tells you something and you say, my lawyer told me this, you've just waived the privilege. And so if you disseminate it broadly, you yell about it in a restaurant, or if the advice is really business advice, do you think this is a good business idea? Those things aren't privileged. All right. So in any overpayment thing, the first thing you have to do is figure out the relevant law. And we're going to go through just two quick examples. One is the one Katie alluded to, the notion that if it isn't written, it wasn't done is not the law. Great advice, not the law. How do we know it's not the law? Well, you look at the Medicare statute. And so the Medicare statute, this portion of the Social Security Act, says that Medicare can't make any payment unless there has been furnished such information as may be necessary to determine the amounts due the provider. You'll notice that the words medical record don't appear anywhere in this statute. It doesn't say that unless the information has been documented by the physician in the medical record. That's not the condition of payment. The condition of payment is unless the information has been furnished, and it doesn't tell you how that information can be furnished. And we've had a great deal of luck prevailing in situations where there's been fights about, for lack of a better term, crummy documentation. Now, I'm not going to walk you through this in much detail. I put them, because we've done it before, but I wanted you to be able to see things like, are these E&M guidelines required? And the answer is no. And so here's the backup support. So the basic principle, if it isn't written, it wasn't done, is not the law. If at this point you've got questions about that concept, we have other webinars that will go into this at more length. You can look through these parts of the slides. It's really important that everyone in your organization understand this, because otherwise you're going to have people walking around thinking you're committing fraud.
All right, so we have our preliminary results from our, let's call it our regular documentation review. And if you're looking at just these results, as David said, Dr. D looks like this could maybe be a real problem. But as David explained, just because it isn't documented doesn't mean the services were done. So if you want to probe further to figure out if the service was actually done, which would maybe be something to do to determine if there is an overpayment, there are a number of different ways that you can figure this out. And I want to point out that the list here isn't necessarily the order that you should follow. It will depend on your specific situations. One of the things that you can do is actually just ask if the service was done. That might involve interviewing the physicians themselves, maybe interviewing the people who work with them. Note that there are oftentimes internal politics going on. If you bypass a physician to interview his or her nurse, that might create some tension. So thinking about all of these aspects is good when you're determining your approach. In some situations, it might be appropriate, or you might think that an interview actually isn't going to give you the information that you need, and you need more of an objective approach, and so you want to use a secret shopper approach. You want somebody anonymously observing the situation so you can gather the facts to figure out if you actually owe money back. Another way you can figure out if services were done that we've actually used a lot in helping clients with overpayment investigations is to look at schedules, people's schedules. For example, in one case, the government was asserting that our physician was not properly supervising the services that were being billed incident to Medicare. And we were able to come back, look at the patient's schedules, look at the doctor's schedules for those days, and show that he or she was actually in the office and meeting that requirement in order to get paid. And so we were able to show, based on information, again, outside the medical record, just internal documents, that the person was actually there and the service was being done. Patient complaints are not something to be ignored. I've actually seen a few situations, even recently, where a patient has taken it upon him or herself to actually review the EOB or the bill and figure out if the codes that were listed on the bill were actually what test was performed. So in one situation, the patient went online and took it upon himself to figure out if the CPT code for the higher level test was actually the test that he got. And this revealed a systemic problem at the client, where they had actually been performing a lower level lab test, but billing all the time for a higher level lab test. So I think patient complaints, definitely you don't want to ignore them for a number of reasons, but they can also reveal issues.
And I'm going to just chime in with 2 points on that. One is, it's easy to dismiss patient complaints as a kook, but we found a situation once where a physician was documenting services not performed, and almost the only way you can figure that out is through a patient complaint or through shadowing. And shadowing is a non-confrontational way that can be really effective to figure out if a doctor is doing stuff that he or she isn't writing down. Having someone sit in with the doctor and observe and just watch what happens versus what's written down can be an extraordinarily effective way to figure out what was actually done. To talk about production data?
Right. So I think, in our example of our reviews, we have basically an issue of, at the very least, we have education we need to do on documentation. But the worst case scenario, services that weren't actually done. And I think one of the best ways to figure out if services were done to actually look at the doctor's production data.
And before we do that, I'm just going to chime in that you'll notice they're not rogue lines on this slide. There are words crossed out, and there's a reason. I hate using the word audit because the word audit suggests it's something scientific, and the government seizes on it to suggest that you need an overpayment. And then also, I think overcoded and undercoded are terrible phrases to use because it suggests you know the proper code. And instead, I much prefer documentation exceeds the code, documentation doesn't support the code, because all you know when you're looking at one of these things is what the documentation tells you. You don't know the proper code. It's possible that someone actually did a 99212 and billed a 99215. We've seen that with what I sometimes call the Happy Meal problem, where you get a history that's carried forward from a past encounter and not the current one.
All right, so based on these results, we're a little concerned about Dr. D, but what we find in our production data review is that Dr. D is actually one of the hardest workers, and she's right at the 75th percentile for her RVUs. So that's seems appropriate given the number of hours she's working and where she's at for her production. Dr. C, however, is raising a little bit of a red flag. He's not even really the hardest worker, doesn't work the most hours in the group, but he's at twice the 90th percentile for RVUs. And this is a little fishy considering physician D works harder and she's at a lower RVU production. So our preliminary conclusions here are going to be that Dr. D seems okay for production data. She's right where she should be, and looks like we need a little bit of a lesson in documentation. But we're not worried about her providing services her not providing the services that we're actually billed for. Dr. C seems to need a little bit more probing here. There might be a reason to think that based on his twice the 90th percentile production data that we need to look a little bit more. And so we're going to go back to that slide about different methods for looking into whether the service was actually provided.
I'm just going to chime in for a second. One slide we didn't include but we should have is the interesting question of, do you have a duty to look? You know, you've got these results. Do you have a legal duty to look? And I think the answer is you don't have a legal duty to look until you know you have an overpayment. You don't have a legal duty to look for overpayments. Now, your compliance plan may impose on you a duty to investigate. And I do think under sort of the common sense thing, when things seem fishy, you're certainly, the government is going to think you have an ethical duty to look. That ethical duty is different from a legal duty. And I believe the legal duty is triggered only when you know you have an overpayment. So I don't think that even Dr. D's data, well, Dr. D's, certainly just those numbers don't create a legal duty to look. But if you don't think about this a little, you should be prepared to get a lot of heat.
So let's just assume that for Dr. C, we found that he wasn't actually providing the level of services that were being billed for in some cases. So the next question is, how in the world are we going to figure out what we need to refund if we billed for things that we actually didn't provide? A lot of people will jump right to the sampling idea, doing a statistical sample to figure out over time how much money is owed. In this case, I don't think that's going to work, because if we do a sample, we're going to look at his documentation. And what we're going to see is exactly what we found in the preliminary review results, which didn't tell us much, because we learned that just because it isn't written doesn't mean it wasn't done. So you're really back to square one with the sampling in this case. Since we've used production data and we think it's a good indicator of what was actually done, I would say continue to use the production data to make your calculation. Figure out, based on all the information you've gathered, what Dr. C actually did, get to an estimate, and refund the difference between what was billed and what was done based on the production data.
Okay, our next example is on the hospital side of the world. And I'm going to go through the legal part of this pretty quickly, but it's an important one because everyone on here who's in the hospital world knows this is a problem all the time. So you discover that you've got a number of patients who spent the night. They may have spent the night too, but they spent it and they were there less than 24 hours. The compliance staff start looking at the medical necessity, and they've got a question as to whether this short stay can be properly considered in an inpatient. This comes up in so many national investigations right now. I mean, it's in everything from kind of the kyphoplasty thing to just the short stay investigations that happen all the time. So the legal analysis here is significant because there's a question, is a short stay really a problem? And I think there's a super strong argument that the answer is no. And here's why. In a nutshell, it's because whoever wrote the Medicare Benefit Policy Manual can't write. So if you look at the text of what the definition of an inpatient is and look at the pink, our first important sentence is, generally a patient is considered an inpatient if formally admitted as an inpatient with the expectation he or she will remain at least overnight. Well, that's easy. If you're spending the night, you're an inpatient. Simple. Let's skip ahead literally 2 sentences. Physicians should use a 24-hour period as a benchmark, i.e., they should order admission for patients who are expected to need hospital care for 24 hours or more and treat other patients on an outpatient basis. Oops, we just shifted from there overnight to do we think you're going to be there 24 hours? Next sentence. However, the decision to admit a patient is a complex medical judgment which can be made only after the physician has considered a number of factors, and I'm not going to read all those factors. We've now got, in the course of 4 sentences, 3 different standards as to what constitutes an inpatient. So the first thing I'd say is, let's say you choose to refund. What standard are you going to use? I don't know the answer to that. You can use, there are services you can buy, Interqual and Milliman, that help you figure out whether someone is an inpatient or not. But that's not official stuff. I mean, I use Interqual and, it's certainly a useful tool, but it isn't the law. So I think there's a really strong argument on these short stays to defend yourself.
And also, David, I jump in and just point out that what we're looking at here is manual language, which brings up another point about when you're looking at the authority of the law, there's a hierarchy, and the first is the statute, the Social Security Act. Well, there's not much there, and so we're usually looking at the regulations, and that comes next, and that's binding. But when you get to the manuals are going to have the same level of authority as your carrier's newsletters are going to have. And so something to think about, Medicare would probably say that manuals are more authoritative, but there's definite legal defenses to relying on manuals versus relying on actual regulations that are the law.
And Katie, you're hitting a sore spot for me because Lord knows I've lost cases where I've tried to argue that those manual languages, when my client has relied on the manual, and so you're clearly right to my ego's detriment. So we're skipping ahead here. I picked this one as an example because I had this is another client who said, all right, we're worried about our short stays. And I said, well, you've got strong legal defenses. And they said, we don't want to use those legal defenses, David. We want a refund. And so we're choosing to refund. And we'll go through that in gory detail when we go through the nuts and bolts of relighting the letter. But so this thing's got really interesting here because so client has a cautious approach they want to take. Oh, so I'm saying, I don't think you need to refund. They're saying, we don't care what you think, David. We're refunding. Okay, great. Let's do it. Because the truth of the matter is clients get to be either more or less risk adverse than us lawyer types. Now, first practical issue they've got a new electronic medical record, and it had the last 18 months worth of records. And they thought they had they weren't sure how far back the issue went, and they're trying to figure out what to do with this. And this is where Katie is going to get into some really interesting stuff. But keep that we've only got 18 months of records thing in your mind.
All right, so in our first example with E&M, we thought that production data and using that to calculate the refund amount is going to be the best way to get the most accurate number. In this case, I think that statistical sampling is probably the best way to go. So now we're into a whole new world that probably everybody hit at some point in grade school and high school, and that some of us were unfortunate to have experienced in college, all of which I've mostly forgotten. But I'm going to delve into the realm of statistical sampling a bit. But before I do that, I want to just make 2 major statements that I'd like you to remember throughout the course of this slide. First is that an overpayment estimate that's based on statistics is only as good as the sample that you have. And the second important point is that statistical sampling is really hard to get right. And that's why there are many experts who spend their entire careers arguing over whether a sample is right. So with that takeaway, what I want to do is kind of explore some of the issues that come up in statistical sampling and make you aware of them should you ever come to this. So you've decided you want to do sampling. First question is, who's going to do it? You could do it, or like I said, you could hire an outside statistician. The expert statistician is definitely more likely to get it right than you are, unless you have an in-house statistical person, of which I'm very jealous. The con of hiring a statistician is that it's extremely expensive, and there aren't very many good ones that I've found who are able to work with the data and who know this healthcare area. And so you're going to have to weigh the costs and benefits of hiring somebody from the outside. Maybe your dollar amount you're worried about is really pretty low. Maybe it's not worth hiring somebody. Maybe you're in a really high-profile case. The government's been breathing down your neck, and you discover this big problem. In that case, you might want to err on the side of hiring somebody.
And I would just say, to put cost in perspective, 5 figures is not at all out of the... I mean, it's you can drop 5 figures in a heartbeat on a statistician.
So the next question is, how are you going to do this sampling? The government, Medicare, uses RAT-Stats, and that's basically a statistical software program that the OIG has developed and that the OIG uses in their sampling, and that a lot of other people use because the government uses it. It's free. You can download it, and I think it's fairly accessible. It's not the only way to do it. There are lots of other statistical packages out there, but be aware that RATstats is sort of the name of the game, at least with Medicare. Now, sampling is going to raise a lot of different points here. The first question you're going to ask is, what in the world am I looking at? What am I sampling? Am I picking claims? Am I picking patients? Am I doing a random day sample? In the example that I used earlier about lower level lab tests and higher level billing, it might make more sense in that case to do a line item search. And I think a lot of this is going to depend, what your sampling unit is going to depend on what you can easily retrieve given your technology if you're the one doing the sampling. The next question is, how many of these things do I actually have to look at? How big does the sample have to be?
I just want to go back to one thing on the sampling unit, which is we've won some appeals on the basis of the fact that the sample excluded underpayments. And so one of the things you want to make sure is that whatever sampling unit you choose is also could look at things that like denied claims and the like. So just as an aside.
So with the size, for what it's worth, Medicare doesn't say you have to have a certain size. And size is just one factor in this whole equation. Clearly, the bigger your sample is, the more likely your estimate based on the sample is to be accurate. But then again, the bigger your size of sample is, the more time you're going to have to spend looking at the units. Another issue that plays into how big your sample is whether there's any variability within your sample. And I think variability is actually best described by how I heard it described by one of the expert statisticians that we worked with, the late Will Yancey, who described variability using what he calls the parable of the footballs and the fish. So it goes something like this. If you have the task of determining the average weight of 1,000 NFL game footballs, how many footballs would you weigh? And the answer would be 1. You only need to weigh 1 because all the footballs are the same, and we know that they spend tons and tons of time to make sure that every single football is the same for every single NFL game. So you only need to look at 1. In contrast, suppose you had to determine the average weight of all of the fish in a particular lake in Minnesota. In that case, you would have to draw a sample of more than 1 because the fish are different in size, shape, and weight. And so because the sample units are variable, your sample is going to have to be larger. So to put it in perspective of, for example, a Medicare overpayment case, sampling units that are very variable may be claims that are right around $10 and claims that are $800. And so it may make sense to do a stratified sample, which is where you take the units that are very similar and analyze them together and analyze them separately from the units that are very different from them. So that's one whole factor to consider in sampling. Precision is another issue. Precision is the measure of how well you can actually reproduce or repeat your sample results. And the thing to understand about precision is that experts and the government and you are going to argue about what is the proper level of precision. The government says that precision need only be within 25%. Other experts that we've talked to say that precision must be within 10%. So something to think about here is be aware of what level of precision you pick. Because if you pick to use the government's level of within only 25%, be prepared that when the government comes back and uses that level against you, they're going to make the argument that you used that and you can't require them and hold them to a higher standard.
And what we're getting at here is you may be talking about 2 different situations. So maybe you're doing a voluntary refund right now and you're calculating it. The question is, on this thing you use 0.25 as your precision level. What if a year from now you're in a much larger overpayment and you're trying to argue that the proper precision level is 0.1? So the sad truth is you have to think about how you'd handle situations in a fight on the front end.
All right, I'll talk about confidence intervals and midpoint and lower bound together. So once you've done this statistical sampling, you're going to be extrapolating your results onto the big universe. And this is where you get the bell-shaped curve that I'm sure most of you are familiar with from some math class in the past. And the bell-shaped curve is going to have multiple different points on it. And at one point, you're going to have to pick which point is going to be your refund amount. What's your dollar amount that you're going to send back to the government? Are you going to pick the top of the bell curve? That would be the midpoint. What's interesting is that the government chooses, and they give you actually, when they're doing a statistical sampling, they give you the lower bound of a 90% confidence interval. So they don't actually pick the midpoint. They say they're doing you a favor and give you the lower point here. So another example of thinking about which you're going to choose. Now, if you choose the midpoint, maybe you have an argument in talking to the government that you've actually overpaid them and that they should just go away and leave you alone because you've given them back more than you ever should have needed to. This next point about dollars per service really just gets to the issue of the fact that payers change their rates over time. So, for example, in the situation where you have, you're going to refund money because you always build the higher level lab test. Well, how are you going to figure out how much you're going to refund? Are you going to use the payer's rate from 2009? Let's say they increased their rate. Are you going to use the rate from 2011? Again, if you give back the higher rate, if you use the higher rate in your calculation, again, I think you have an argument that you've really cleansed yourself and you're giving back more than you even should, so hopefully the issue will just go away. David talked about offsetting underpayments. Clearly, it seems like if you offset the underpayments, you're going to get a better estimate, but the government doesn't necessarily always do that.
But there is some pretty clear guidance that they're supposed to. So I think one of the points Katie's making here is you may and often will choose to over-refund in a refund situation. And we'll talk a little bit more about that when we get to the letter. So some of it gets to whether you're trying strategically to say, we're over-refunding, in which case you may want to exclude underpayments, or whether you're trying to get to the best answer you can, in which case you would include the underpayments. And legally, I think including you have a right to include the underpayments. You may choose not to for strategic reasons.
Now, the universe is the total number of relevant units you're looking at. Now, if you're worried, if you decided that the rule that you've failed to follow is a condition of Medicare payment, but it doesn't really relate to any other payers, it makes sense to really only look at your universe as Medicare claims. However, I think in the case of where you realize you didn't actually provide the service, this would probably apply to all payers, and so your universe is going to be bigger, and it's probably going to include all of the payers. Another issue to look at is, to think about, is whether you can look at 1 year and project it to 3. Now, probably not, because each year is different, and looking at 1 year may not be reflective of what happened in years 2 and 3. But as we go back to our example, in our hypo, we had an electronic medical record system that only went back 18 months. And so 18 months might be as good as you can get, and that's what you might have to settle with.
But, so what had happened in this instance is I've got a client that wanted to look at 18 months. They took their 18 months and we're going to project it back. And that's the sort of thing that if the government tried doing to us, I would be screaming and pitching a fit. And so once again, you got to be careful, because are you setting a standard that you can live with if the government does it to you? And if not, you got to figure out a way to explain how what you did is okay. And like in that case, the answer to me would be come up with some rationale as to why you're refunding more than you think you need to. In that case, the answer would be, I don't think you need to refund anything, because legally there was no overpayment at all. And so whatever we did was extra generous. But you got to be really attuned to the hypocrisy issue.
One of the biggest questions that we get is, how far back do I have to go when I'm looking at this problem? And there's a lot of debate about this, but the first question that you should ask before you get into whether you're talking about 3 years or 4 years or 1 year is, when did the issue come about? When was the point in time that you realized, or when was the point in time that your system broke, for lack of a better word, so that you weren't providing the service in the way that you were supposed to in order to get paid? If that point in time was within what David's going to talk about, these various periods that we like to refer to as statute of limitations, you would only need to go back to that point in time. If that point in time occurred in 1980, I think you're going to have a more complicated question.
Okay. And I think I'm just skipping ahead here because I'm trying to remember if we have a slide that deals with how far back do you go with private payers, and I think we do. But the slides I'm going to do right here focus mostly on Medicare. So first of all, Medicaid doesn't really have a limit in almost any state. It's really frustrating. In fact, there's a case out in New York that argues that Medicaid can go back forever. It's a really disturbing case to read if you happen to be in New York. Medicare has a number of limits. So people often talk about the False Claims Act that has this 6-year limit or up to 10 years if the government wasn't aware of the situation. But most billing errors aren't false claims, so blow that off. I mean, I think the False Claims Act isn't really relevant to our analysis. For private insurers, the first place you'd look is your contract, but the next place you'd look is state law. And if you have a contract, it'll be the contract statute of limitations, which is generally going to be about 6 years, but vary from state to state. If you don't have a contract, then there's a generic statute of limitations that would apply, but you'd have to look at your contract. For Medicare, this is where things get really, actually even more, they get weird here. But basically, there's a law that requires the government to waive an overpayment when the provider or supplier is without fault, and recovery would violate equity and good conscience. Now, the stuff gets super hyper-technical here, and we're not going to spend a lot of time on this because I want to get to the how to write the letter and leave lots of time for questions, which hopefully are pouring in. But so this statute actually technically only applies to denials that are based on medical necessity. And not all denials are, but let's just pretend that they are because there aren't a lot of statutes that deal with any other situation. So the statute says that if that there's a presumption you're without fault. Is triggered 3 years after the year in which payment was made. And this is a headache inducer on multiple levels. One of them is generally you don't keep track of when payment was made. You know when a service was provided and when it was billed, but the date of payment isn't usually easily accessible. And if you think about how you operationalize this, it's really ugly. So if you do a service in December of 2003, it gets paid in February of 2004. The government can recover any time up until the end of December in 2007, which is 3 years after the year 2004 in which payment was made. In the quirky quirks of life, if the claim had been paid a little faster, just make it 4 weeks faster, that takes a year off of the recovery period. Good grief. But there's another mechanism in the manuals, which, as Katie's pointed out, is below in the hierarchy. The manuals are lower, but this is so much easier to use. This is one of those rare times I'm like, I take easy over legally binding. And the manuals basically say that they can reopen a claim for 48 months unless there's fraud or similar fault. And I'm going to blow through fraud or similar fault really quickly, but basically it's the things you'd expect. It's deception. It's something that approximates fraud, like concealing information. It's oh, please, oh, please, oh, please, as you've written cat food, cat food, cat food. That's fraud. It's if you know something is incomplete, you bill for things that weren't provided. We're just going to skip ahead. It's inadvertently, Roy dooms the entire Earth to annihilation when in an attempt to be friendly. He seizes their leader by the head and shakes vigorously. Well, that one might be inadvertent, and that doesn't seem fraudulent. Or, ha ha ha, Biff, guess what? After we go to the drugstore and the post office, I'm going to the vet's to get tutored. You don't know factually if that's a mistake or if that's deception. You'll figure it out. But basically, 48 months for Medicare is our test.
Some of the facts that you want to consider if you're considering this without fault defense are here in the slide. So, for example, a hospital who has an independent medical staff, the medical staff isn't employed by the hospital, may be able to say in some situations that the hospital is without fault for an overpayment based on a short stay because the hospital relied on the physician who admitted the patient. It's a lot easier in that situation to rely on the physician and say you're without fault than if you actually employ the physician and you've given multiple in-service trainings on short stays. This is the same is true if you're relying on physician orders. It's really hard to question a physician order, and so that would be one way you could say you may be without fault. That might work. Another question that people often ask is, what if I rely on outside consultants' advice? And I think in this case, it depends on what the advice was, I think whether you should have relied on it. And so in some cases, I think that relying on outside consultant advice can get you to without fault.
Okay, so the bottom line is you're going to go back for Medicare. 48 months is kind of your cutoff in most cases. And our computer is hiccuping here a little bit, so we'll let it catch up to us. Okay, so now we're going to probably get to the most important thing here, the refund letter.
All right, a lot of people ask when they figured out that they've probably been overpaid, but they're not sure exactly how much. They ask us, do we need to send a letter now if we're going to send a letter later? And I think for the majority of cases, we would say don't send a placeholder letter. You don't have a legal obligation to send a placeholder letter. Your timeline runs once you've identified the overpayment. Your 60 days runs then, and then you'll send a letter within those 60 days. There may be some facts where you would send a placeholder letter. One example may be where you think that the internal review and determination of the overpayment amount is going to take a really long time because it's a really complicated issue, and you're afraid that the government's going to catch you with your hand in the cookie jar. In that case, depending on the circumstances, it may be in your interest to send a placeholder letter saying, we're looking into this. The next question that we get a lot is, who writes the refund letter? Who's it from? And kind of the threshold question is, that we get a lot is, should this be from the attorney? And again, I think more often, if it comes from you, it's better. Letters from attorneys scare people, and they put people on the defensive. So the general rule should be that the refund letter comes from the client. Well, who within the client? This should be somebody, the person who signs the letter should be somebody who's comfortable with talking to the government, who's appropriate to talk to the government in an investigation. I think the compliance officer is sort of the first obvious choice, but you have to really look at who's in your organization and who's going to do the best job of communicating.
Okay, the next question is, who should it go to? And to me, I'm a big fan of taking the government at their word. So one of the kind of questions, should I use the OIG self-disclosure protocol? Do I call the OIG? Do I call my U.S. attorney? And I would say no, unless there's fraudulent conduct. And the government has, at various points, issued statements. Eric Holder, who is a deputy attorney general, or actually now attorney general, but at the time he was a deputy attorney general, said, there's a distinguishing between fraudulent conduct, which is intentional or recklessly fault, and innocent mistakes. Honest mistakes aren't false claims. Take the government at their word. If you don't think someone should be kind of basically going to jail for the sin, you don't, in my mind, ever use the OIG self-disclosure protocol. You don't contact your local U.S. attorney. Now, you have to keep an open mind. I'm working with one system where they think they've got a great relationship with the U.S. attorney and a pretty bad factual scenario. And in that case, working with the U.S. attorney might make sense. But generally speaking, I'm not going to the U.S. attorney. It's not on the list. The next question you have to figure out is how much detail to provide. And what we're going to do now is kind of start going through some sample letters. I think you want to provide as little detail as possible. You have to make absolutely sure it's accurate. I mean, you have to tell a story, so you have to have a why. I like my why to be about 2 sentences long. And remember, a misstatement in your refund letter arguably creates false claims liability, or at least potentially. So accuracy is really, really important. One of the issues that comes up a lot is when you have a situation with a small amount of money and you aren't going to determine the exact amount because it's too hard. Those in some ways are the easiest letters to write, and we'll talk about the language in a second, but you're writing a short letter that says, look, we believe this might have been improper. The cost of investigating it isn't worth, would exceed the cost of the overpayment, so we're just choosing to refund this money.
One question that comes up a lot, David, about detail is when you're doing statistical sampling, how much detail do you provide about what you did for the sampling? You certainly, I don't think, want to go into a long description of how you selected the sample and what your precision is and that sort of thing, because I think that just leaves areas for the government to poke holes in. But certainly if you did a sample, it's something to consider is to say we did a sample, and if you used rat stats, maybe that you did rat stats because that's what the government uses and they like that. But other than that, I wouldn't delve too much more deeply into what your statistical sampling was.
Okay, now Katie's going to talk a little bit about things you don't say, and then I'll cover some stuff that you do.
All right, so here we have a couple sentences from a hypothetical refund letter. The first sentence says, we recently discovered that one of our physicians was committing billing fraud. Now, I think the latter highlighted part of the sentence is sort of obvious why you don't want to basically make an admission to the government that you are committing a crime. I think instead what you want to do is use phrases that say, we recently discovered an issue, or we discovered that there may be possible issues in whatever area that is. Also, with the word recently, I would take out language that is temporal. I don't think you want to let the government know when you discovered it, because then that gives them an argument that you should have turned in your refund earlier.
Okay, so we have comments here about she wasn't documenting services properly. Well, as we talked about legally, I don't think that's a legal argument. And so I wouldn't phrase it that way. It's proper, and what I particularly don't like is proper. And so we might say there isn't documentation to support the code build, but that's another one. You don't want to say it that way because there might be all kinds of other situations where there isn't documentation to support the code build. So what we're going to be going with, and you'll see this on the next slide, you might say something like, we want to take these to the level we're confident defending. Or what I'd probably say is, we're not convinced that the services were performed as billed. I'm much more a fan of such phrasing. I hate the word inadvertently in here because I don't think you ever inadvertently billed. You did appropriately.
The statistically valid sample is a problem here because, as we talked about just a few minutes ago, there are a million ways you can screw up a statistical sample. And to say it's valid really opens the government to be able to say, well, that isn't valid for these 6 million reasons why. And also this last sentence here, we have corrected the problem. This really, I think, shoots you in the foot. It sets you up for setting yourself to a standard that the government is going to expect from you in the future. And if you didn't correct the problem, and you said you did, then that could be a problem later.
So let's look at some wording that you should use. So first of all, a great way to start these things is...
I like to say something to the effect of, as part of our ongoing compliance process. And I like to say that for a few reasons. First, you want to show that compliance is important. And you want to be able to open the letter without just saying, hi, here's the money. But it also doesn't include a time, and so you aren't sticking yourself to a timeline.
I like the phrase more appropriate is just, it's a better way of framing things than right or wrong, identifying possible issues. One of the important things in a letter is you want to reserve the right to recant. And I want to tell a quick story here. Had a client that wanted to refund some money, this was years ago, about services that were performed incident to in the hospital. There was a strong legal argument that even though there was administrative guidance that was improper, that there was confusion and that therefore they were without fault. But they insisted on refunding what amounted to about $330,000. So I wound up writing that letter. This is a time where a letter from us is better. And in that letter, I said I didn't think they needed to refund that money, that there wasn't a legal duty to, but they were choosing to anyway, and that if the government wanted to assert any more money, we were going to reserve the right to challenge the voluntary refund. Well, the government came back and said we hadn't gone back far enough. We used that reserve to recant argument, went before an administrative law judge. The government actually sought another $800,000. We appealed. We got the whole $1.1 million back. It was one of my favorite moments as a lawyer. And it all came from how we crafted our overpayment letter. We've talked about the level we're confident defending, but another thing you don't want to put in your letter, our attorney has told us, as soon as you do that, you're arguably waiving the attorney-client privilege. Wording in the letter, I try to avoid using the term overpayment and instead focus on refund. And it gets to this difference. I don't necessarily want to be admitting that the money we got was money we definitely shouldn't have received. I want to preserve the option of arguing that we are over-refunding. And then Katie talked about the steps to improve. It's good to say you have steps to improve because that way it's not representing that the problem is definitely fixed.
I also think it's important to remember at this last point that your letter isn't really to tell the government what you're doing to get better. It's just to give the money back and to give a reason. So don't feel like you have to elaborate on what you've done to get better.
All right, we got just a few more things to do, and we got not a lot of time left, so let's hum along. You worry, if you send this letter in, are you going to wind up like the poor guy in this cartoon? For better or for worse, we've had very few clients who have written the disclosure letter and then lived to regret it. I will note This is a letter I got back in 1999, a long time ago, and I still periodically see them where the government basically is saying, we took your refund, but if you look at paragraph number 2, they're saying, just because we took your money doesn't mean we can't collect an overpayment from you again. The letter is kind of a crock, but I still do see these sometimes. So now we're just going to do a few commonly asked questions. So one of them, should you try to keep your reviews confidential? And I would say sunshine's a great disinfectant. I'm a fan of keeping stuff open and having an open process here, but reasonable people could differ.
All right, should you ever ask the payer what the rule is or whether you have to refund something? This is a really tough call. It's going to depend on the facts. Couple points if you do decide to ask the payer. Disclose all of the relevant facts and use the proper terminology. If you're a hospital, don't use the word Medicare supplier because that could actually change the answer. So make sure that you're reviewing what you're telling the payer before you actually ask. The second point here is get it in writing, or better yet, give the advice in writing. If you can get the payer to say in writing what the rule is, that's good. But it's better if you get to tell the payer what the rule is, you send it via certified mail, you tell them that's your understanding, and then you don't hear anything ever. I think that's a better fact scenario because it shows that you agreed on what the rule is, and you told them, and they didn't object. And then finally, make sure you aren't incriminating yourself as evidenced in this next cartoon. There we go. If you're going to approach the payer, make sure that you're not saying, well, we think we screwed this up, but we're not sure, please help us. That's really going forward with your shark fins up. Rather ask a very objective-like question.
Okay, so Katie and I drew straws as to who was going to have to do with what you do with co-payments question, and I drew the short one. I hate this question. I don't think the law is clear. I know most people don't really deal with the co-payments. You know, I view double billing someone for a co-payment, that I want to deal with. But in other situations, if you're refunding, what do? I do think the size matters of the co-payment, if it's a deductible or something like that. If you would bill the patient if they owed you this amount, I think that makes a stronger argument you have a duty to refund. If you would write off that amount if they owed it to you, I'd feel a bit better. You do have to know your state law here, but this is one that just gives us a headache.
A lot of times clients say, okay, well, we're going to refund, but do we need to rebill the claims? I think generally we say refunding is the way to go, and rebilling really doesn't help you that much. First of all, you have this timely filing issue, and as all of you know, Medicare scaled back the time that you can submit claims to 12 months. So rebilling may create an issue if the date of service was long before the time that you're billing. The downside to just refunding, however, is that all of your bad claims data are still in the system. So that could leave exposure to when some other sort of reviewing body comes along to see if you've done anything wrong. And if you haven't rebilled, then there's a possibility that you could get dinged twice or have to deal with the issue twice.
Which brings us to really the big next question, which is how do these refunds affect RAC audits? And there's a huge tie-in between these two. Let's say you do a statistical sample and you refund a bunch of money, if a RAC could audit one of your hospital claims, and on some level you may have refunded it, but you haven't refunded it for that specific claim. This is territory that is kind of uncharted, because you didn't refund on any particular claim in your sample, except that the handful of the ones that actually came up in the sample. You've refunded on a percentage of all that's left. I think where you wind up then is if you've got a RAC audit on an issue, you have to sort of then figure out what percentage of that money has already been refunded. Administratively complicated, but it's something to think about. And whenever you are in an overpayment or a RAC situation or a voluntary disclosure situation, you have to kind of think about how you can figure out if some prior refund may have arguably affected the amount at issue here.
We've done a lot of talking in this webinar about the government, but it's important to remember that private payers are out there too, and they have different rules, and those rules are going to be governed by what's in the contract. Be aware that many private payers say in their contract that the manual counts too. So I'm sure most people haven't read from front to end the private payer manual, but those rules could very well control your services as well. The refund requirement that we talked about at the very beginning is only a government requirement, but healthcare fraud is iterated in various state laws and is a federal crime as well. So keeping your overpayments for private payers isn't necessarily okay. State law is going to govern how far back you go, for example, and also what the statute of limitations are for when a private payer can come and ask for money back. And another question that has perplexed us for a very long time is, are Medicare Advantage plans private payers or are they government payers?
It only perplexed us until you figured out the answer, Katie.
Well, we think that the answer is that the traditional Medicare rules do not apply to Medicare Advantage plans. And we've done a really thorough look at the law. And what's interesting is that if you call Medicare Advantage and ask them this question, they'll refer you to traditional Medicare. And then if you call traditional Medicare, they'll refer you to Medicare Advantage. But importantly, there's nothing in the Medicare Advantage laws that says all of those other Medicare rules apply to Medicare Advantage payers too.
Now, we haven't got as many questions as I expected to see at this point. You can pour them in, because we've got a little bit of time yet to do them. But here's a good one. So you stated that most billing errors are not false claims. If you're aware of the error, however, and do not repay, does the billing error now morph into a false claim?
Well, I think first of all you have to look at what billing error is. Is the billing error actually an overpayment? Did you look at the law and did you figure out that you didn't provide the services in order to get paid the way you were supposed to? If that's the case, and there is an overpayment, and you've sat there for longer than 30 days, what the healthcare reform law did was basically said that overpayment that sat there for 60 days turned into a false claim.
And Katie just gave a better answer than I would, because she picked up a nuance there that's important. If the error was you had the date of service wrong on the claim, I would argue that's not a false claim because the money is there. But if it's an actual overpayment, that's one of the changes that was made to the False Claims Act, 2 years ago, something like that. Keeping an overpayment now is a false claim, which actually raises interesting, like, how far back do you have to go questions. And I think the answer to that is you still have to go as far back as 48 months. Basically, after 48 months, the overpayment turns off, and that makes it not a false claim. Now, we're having a bit of a technical hiccup here, so bear with us for one quick second. So I think saying the word Medicare Advantage immediately starts triggering questions in people. So this one's hot off the printer. Regarding the refund versus rebill question, we chose to refund, but had several Advantage plans that insisted that they had to adjust the claims data and asked for claims detail. This creates a lot of manual adjustments that aren't practical. Are we required to comply with their wishes? This is a great question, and it kind of gets to this whole refund, rebill thing. I've had a lot of private insurers say, you have to rebill. I mean, they'll come in and say that. Now, first question, look at their language with you. What's in the contract and what's in the manuals? Do they have to is a contractual term. I think, I'll tell you this, even if they require you to rebill, if they then turned around and denied your claims as untimely filed, that's one where I'd fight them and go to the insurance commissioner, because there's something really skanky about, let's make it a situation where you billed $15 and you should have billed 10, and their argument is you've got to rebill, and then they're going to deny the 10. The legal framework there isn't crystal clear, but I know how I feel about the equities, and I'm going to fight that one tooth and nail. But the short answer is you've got to look at those adjustments, or you got to look at your contract. It does create a headache, and it creates a headache for them too. But I'm hearing this from all kinds of people. I know of no authority that allows them to require it. We've lulled people into a sense. I don't know. I guess
hopefully
maybe
the statistics didn't do it to you.
Yeah. Well, or that's so. And I thank you all for not telling me the soccer results. I feel really much better about that. So let's see. The next webinar. No August webinar.
Next webinar, we're going to do, I don't want to call it a health law boot camp because that doesn't sound very fun, but health law primer sounds kind of boring. So I'll just try to describe it, and that is we're going to tell in-house attorneys what they need to know, give them a really solid overview of healthcare laws and issues that are out there.
Yeah, think of it as an intro to the anti-kickback statute, Stark, HIPAA, and the like. What to do when government agents show up, that sort of stuff.
Enrollment issues.
The other thing is maybe by then, Minnesota has a past history of leading the nation, or not in healthcare, where I don't know if leading is the right word, but managed care certainly got its start here. I think we're doing a test run right now of the government shutdown, and we may have the feeling that we are showing an example of what may happen on a federal level on that, and I fear that our next webinar may be covering real estate like what happens when your government stops providing services.
Let's hope not.
All right. Thanks for listening, everyone. You can always email either Katie or me questions afterwards, and we appreciate your time.